Okay, guys, I'm going to show you one of CPS's tactics that they
CPS loves to come with these fake warrants. It's useless pieces of toilet paper. But what must a warrant contain? Let's look to the Supreme Court. And you can see there's lots of Supreme Court cases in this book for you fact checkers. Yeah, we come prepared. According to Mincy versus Arizona, a warrant is a written order signed by a court. Does that look like the signature? No. E-filed. It must be signed by a court. It cannot be electronically printed, and it cannot be rubber stamped. It must be signed by a court, authorizing law enforcement officer to conduct a search, seizure, or arrest. Searches, seizures, like when they take your children, seizures, and arrests performed without a valid warrant are deemed presumptively invalid. And any evidence seized without a warrant will be suppressed unless a court finds that the search was reasonable under the circumstances. But let's go on. The application for a warrant must be supported by a sworn, detailed statement made by a law enforcement officer appearing before a neutral judge or magistrate. Neutral judge or magistrate. So if the same judge you are being seen by signed the warrant, that is a violation of due process. It must be a neutral judge. Not neutered, neutral. The Supreme Court has said that probable cause exists when the facts and circumstances within the police officer's knowledge provide a reasonably trustworthy basis for a man of reasonable caution to believe that a criminal offense has been committed or is about to take place. See Carroll versus U.S. Probable cause can be established by out-of-court statements made by reliable police. That's why you always make sure that you ask for the police officer's history. Do a FOIA request, Freedom of Information Act, and demand that the police officer's misconducts be brought to light. Because what does it say? Reliable. If he's not reliable because he has multiple misconducts, it can be stricken and the case can be dismissed. Reliable information, even though those statements cannot be tested by the magistrate. See, police are allowed to lie and the magistrate cannot test them. So what else should the warrant say? I told you this is a big book. Oops, one too many. U.S. versus Hotel, a federal court case from the Ninth Circuit to comply with the Fourth Amendment anticipatory search warrant either must on its face or on the face of the accompanying affidavit. Now that's important because read the Fourth Amendment. They must have an affidavit to support the warrant. Even CPS workers. And guess what? CPS has no first-hand personal knowledge. So they cannot sign the warrant. It is all hearsay if they do and invalid. And the affidavit must clearly, expressly, and narrowly specify the triggering event. That is referring to probable cause. Consent to search that is given after illegal entry is tainted and invalid under the Fourth Amendment. Plain view doctrine did not apply to the seizure of evidence from defendant's residence after officers conducted initial search based on invalid anticipatory search warrant. The plain view doctrine does not apply unless the initial entry is lawful pursuant to a valid warrant. Don't let CPS blow smoke up your ass and just hand you a useless piece of toilet paper. Make sure the warrant has those checkpoints. Judge's wet ink signature. No rubber stamps. No electronic filings. I've held a loaded gun, brandishing it to officers, handing them back their warrant and go, let's make this peaceful. Get the fuck off my property until you get a signature on that warrant. And they left. They must follow that procedure. And the mere fact that they haven't in your case, I already got the answer. That means they've violated due process, they've lied, they've committed fraud, and they have no jurisdiction. Always, criminal, CPS, any court of law, always challenge the warrant. Have a good day, Dallas.